Good morning. Good morning.
Good morning, Judge.
Okay.
And how are you this morning?
We're good. We're online at last.
Just a moment, Judge. I'm struggling with my volume.
Good morning.
Morning, Advocate Morotiwe. Are we ready to start? Which matter are we proceeding with first?
My lady, perhaps I should call mine first. Mokonoto for the applicants. It's case number 4 of 2020. The one against MP2 Trading Enterprises and another.
Okay. Sure.
My lady, perhaps I should clarify. I don't know, the last time you had indicated that you weren't as familiar with these case lines issues, but we have at bundle 24 of case lines a notice of withdrawal as attorneys of record by Mahlangu attorneys who had been representing the respondents. The notice is dated 2 May. And I would want to believe that there are no appearances on behalf of the 2 respondents.
Can we confirm
that? My lady, yes, I can confirm that there are no appearances on behalf of.
Mr. Rulani, who do you appear for?
I am the one appearing.
Unrepresented. Do you know whether they've been notified that their counsel have withdrawn?
My lady, the erstwhile attorney has filed a notice of withdrawal as attorney of record.
Yes.
And I will take it that in compliance with the rules, the uniform rules, of course, that notice of withdrawal would have been communicated to the respondents themselves.
Well, the procedure that we have is, if it is so, then we usually have a return of service of the withdrawal on the parties concerned. Do we have that?
My lady, I do not have that. This notice of withdrawal was only sent to us on the 3rd day of May, dated 2nd day of May. Other than the duty in terms of the rules being on the part of the attorney to have notified his clients, we have not had the opportunity. It had been inopportune on the constraints of time for us to serve the notice. And in any event, as I have indicated, that the duty in terms of the rules and established practice is that the attorney ought to have served this notice on the respondents.
Yes, but even though there's established practice, it is usually a matter of, I think, the belt and braces approach that you attach to that notice of withdrawal, a proof that it has been served on the other parties. I don't know that it has been. I mean, I can't just take it for granted that the attorney has done his job. These days, it often happens that they do not.
Well, my lady, I have not served this notice on the respondents for 2 reasons. Firstly,
but not your duty, as I said. It's not your duty. You serve the notice of set down on the attorney at the time, but the attorney has withdrawn and he's not indicated whether he's informed his clients that that this matter is proceeding today or that he's withdrawn. So my difficulty is, how do I know that for a fact?
my lady, I would not be able to make any submissions on a factual basis in relation to whether when the respondents are aware of the withdrawal or not. But my lady, perhaps I will only indicate that there has been communication between my attorney and the attorney, the SIU and the attorney, and even in those communications, they have been limited only to the SIU and to that attorney, Mr. Mahangu. And that is all. But perhaps also, just to reiterate,
your instructing attorneys may have said to the attorney, did you notify your clients that the matter is proceeding today, or something to that effect?
My lady, my attorney had, after engagement with these attorneys, only made them aware that in the event they are withdrawing, they will have. My lady, if I may.
Yes.
I am advised that the attorney is also involved in the next matter that you have on your roll, and that perhaps if we stand this matter down momentarily, or at least for the duration of the next matter, he can then confirm, provided he is available.
Yes.
Well, if he's not available, my lady, I will be asking for orders by default, my lady.
All right. And while we on that, Mr. Mokonoto, I seem to recall dealing with this matter at some stage. Was it in January this year or March?
It was in March, my lady, on the 4th of March.
I don't have that court order. The court order that I had issued, a typed order.
Yes, my lady. Well, I have
no idea what I ruled on that day.
My lady, perhaps Ms. Mashitisho can assist us in that regard. But for my submission, I will say the matter was then stood down to today, with us having been directed to file a substantive application for leave to file a supplementary affidavit by the 8th day, or was it the 22nd day of March, which we did, or rather the 8th day, and the respondents having been directed to file their opposing papers by the 8th day, if they would have been inclined to so oppose, which they have not done, my lady, but we have filed that substantive application. And perhaps, as I indicated,
not 48, 041 to 048. How, what's the page reference to your notice of application?
048 from 207, my lady. That's the one that you have.
That's the one I'm reading now.
That's the court, please, my lady.
Okay, let's just confirm from the attorney, please, in the meantime.
Mr. court, please, my lady. I will step off for a moment then, whilst the next matter is called.
Milton Wakanoto, do you know what's happening?
My lady, my brother will address you now in respect of the next matter. Mr. Moreto?
Oh, no, I don't want to jump from one to the other.
Oh, okay.
I want to,
yes.
Yeah, I don't want to jump from one to the other because I've got a small table and I can't, I've got to move with files. I can't keep opening different files here. It's difficult.
Okay.
So let's deal with your one first, and then we'll proceed to the other one. Now,
Okay.
has the attorney confirmed that they notified the respondents?
My lady, thank you for your indulgence. I can confirm that we have now tried to call the attorney on both the two lines that we have for him, and that both of them go to voicemail. So we are unable to make any contact with him.
He's online with this matter.
No, my lady. I meant my colleague, Mr. Mretwa, who is dealing with the next matter for the SIU. Mm-hmm. And I was saying that even in that matter, the respondent's attorney, the withdrawn respondent's attorney, Mr. Matlangu, is on record as representing the respondents therein. But I know.
Then why isn't he here? Because if he has a matter before me in the other matter, don't you think he ought to be here?
He should be here, my lady. But I say he is not there.
Why?
My lady, if you recall, even on the 4th of March, he was not there. We had to call him for us to be able to proceed. We only got hold of him, and then thereafter he connected. So I am not able, in the very least, for the next matter. Well, not mine, because he has filed a withdrawal notice. For the next matter, and don't notice or any point.
Withdrawal.
No, is there a
name? I need to report him. What is
his name? Is Nhlanhla Mahlangu. Nhlanhla will be NHLA. Mm-hmm. And then again NHLA, that is Nhlanhla. And then Mahlangu is MHLA. Wait a minute. MAHLA NGU. That is Mahlangu. Yes, and he is with NG Mahlangu attorneys.
Okay, thank you.
My lady, before might I assist?
Yes, Mr. Morris.
My lady, I appear in the second matter.
Yes.
I just got hold of Mr. Mahlangu now on his phone. He says he did not get the link because in the area where he lives, there has been load shedding for the past 2 weeks. They have not had electricity for the past 2 weeks. So he just drove to the other area called Mabatu, and when he got there, he found that they are also load shedded, and that affects network. He did not receive the link for this hearing. That is his explanation to me. He says electricity will come back in their side at about 12. I don't know if that is of any assistance, Marida. I just thought I should.
Because the matter was set down for this morning. I can't sit and wait for him, unfortunately.
Indeed,
he should have made arrangements. We all anticipated load shedding, and we've made alternative arrangements. So that excuse is not going to hold water. He's not here, and that's it. We deal with it as if he's not here, unfortunately.
Yes, Malay.
I think you need to tell him that. He needs to buy some airtime or mobile data and connect via mobile data, because a lot of us are doing. You don't rely on you don't rely on electricity for mobile data. I think tell him, connect through mobile data, get him, buy him some airtime, but he can't do this. He knew a
Yes.
long time ago. He knew a long time ago, and the schedules for the load shedding is well known in advance. So he cannot tell me that he has a problem and he's not done anything about it. I'm sorry. It's just not going to hold water.
Let me give him a call, my lady.
Yes, I
I'll
think
report back to the
yeah.
tribunal.
Okay. All right. And also at the same time, confirm whether he's notified his clients in the other matter. Mr. Mokonoto's matter, please.
Okay, my lady.
Office withdrawal, yeah. Thank you. Thanks. I'm just going to sign off now until you come back to me.
No.
Oh, you asked?
Mm.
Oh, okay.
Tiro,
I
Tiro.
asked him to call.
Tiro, Omogril.
I found him, but when I tried to get back to him again to confirm that issue,
Yes.
he's not picking up.
This guy is not serious.
All right, no, thanks.
Okay.
Okay. Are we back
My-
in line?
Might I address you, my lady?
Yes. Yes. Proceed. Can you hear me? Can you hear me?
I can hear you, my lady.
lady.
Okay, good. Mr. Moratiba, you're going to say something?
Yes, I had just spoken to Mr. Mahlangu.
Yes.
He says, with regard to the first matter that your ladyship is dealing with, he
Yes.
says he did send the notice of withdrawal via email to the respondents. He says he sent it to the husband. That's what he said.
Well, as
I'm
long
not
as
sure which one is the husband on the respondents.
but it doesn't matter. It was sent. He says it was sent. Sorry,
My lady?
I don't know why we can't seem to be able to have a conversation. What is? Can you not hear me?
Yes, I struggle to hear you, my lady.
Is it mine is on its max? My sound is on its max. I don't know. I don't know if we can carry on like this because you can't hear me.
My lady, I can hear you well. Perhaps we may have overloaded the system. Perhaps if I may be allowed to leave to come in, my lady, my brother has confirmed that indeed Mr. Mahlangu has notified the respondents. So
Yes.
insofar as the first matter, perhaps the requirement has been satisfied,
Yes.
the respondents are aware that the matter is today and that their attorney of record has withdrawn.
Right. So what do you want to do?
My lady, I would ask for the orders as prayed for in the notice of motion in respect of the application for leave to file a supplementary affidavit. And my lady, in respect of the main application, adjusted, the first prayer being adjusted in accordance with the amount reflected in the application to file a supplementary affidavit, which amounts I can make available to her ladyship, my lady.
All right. Well, in her absence, I'm going to grant the application to file the supplementary affidavit together with the annexures.
As the court please, my lady.
Okay.
And in respect of the main action, my lady,
With
the two applications were ought to have been heard simultaneously, my lady. The one is an interlocutory And once we are done with the one, we proceed to the main application.
Yeah. There was only one, the issue I have is that on what basis should the second respondent be held liable in this matter? Because it's not been set out very clearly in your founding affidavit on what basis I must pierce the corporate veil. There's nothing there.
My lady, we explain and we are relying in the matter of RI Marco versus, the SIU and another versus RI Marco, wherein the court had found, as we seek relief, but the fundamental being, my lady, if I may explain, the fundamental being that the second respondent, or perhaps I should say the first respondent, is merely a juristic person. And for the second respondent to carry out its business, it had always relied on the second respondent, and that it is the second respondent who had been running the day-to-day business of the first respondent, being the one who had committed these overstatements or fraud, as it has been found in the case of RI Marco. And that being the case, and on the strength of, my lady, if I may, on the strength of section...
All right. Mr. Mokonoto, where in your founding affidavit have you set out clearly the basis on which the corporate veil had to be pierced?
My lady, in the founding affidavit, we merely make allegations and we do not set out clearly the basis. This on the understanding that it becomes a question of law. It is a subject of legal interpretation. So having gone to town about...
But you've got to set them clearly the basis on which, if you want me to hold somebody liable, you've got to set out very clearly the basis on which you feel. It's not simply just make the allegation. You've got to set it out. I think in the cases that you're referring to, it was set out. The basis was set out.
Yes, my lady, it was set out in our heads in that matter. And in that same matter of Marco, the tribunal had correctly relied on the case of Department of Agriculture, Forestry and Fisheries and another against Tulu and partners in arriving at the conclusion that the corporate veil was to be pierced in terms or perhaps the invocation of section 29 A and B of the Companies Act. It's by virtue of operation of law, because the Companies Act is legislated, my lady.
But it has to be shown that they were controlling this improperly.
Yes, my lady, hence my submission that first to clarify that the first respondent is merely a juristic person who relies on the actual input of the second respondent for its day-to-day business. And it is the second respondent who had been conducting business on behalf of the second respondent of the first respondent in the name of the first respondent, perpetuating the allegations that are found in our founding papers, my lady.
But what was that? Was that CC created for a fraudulent purpose?
My lady, the company, the first respondent, may or may not, we don't know. That is not an argument we want to make as to whether when it was created for the perpetuation of fraudulent activities or not. But what we do know, and what we will submit...
That's what was found in the Cape Pacific matter, that they were involved in fraudulent activities.
Exactly.
That's not... Yeah.
If I may just make this submission, my lady, what we do know is that in the case before the tribunal, the second respondent had perpetuated acts of fraud in the name of and on behalf of the first respondent. It is the second respondent who was running the day-to-day activities of the first respondent, doing making the submissions, filling out the claim forms and all those things. And even the benefit that has been received would have been payment to the first respondent for the enjoyment and benefit of the second respondent.
But the transactions were not part of a sham or a cloak as is required in Knoop's case. It was clearly not that situation. They were genuinely providing a service. They inflated their bills, but they were genuinely providing a service.
That is correct, my lady. They were genuinely providing a service, which they did. But that service, my lady,
was clearly created for a lawful purpose.
Yes.
So it was not created for fraudulent activities, etc., except that they, for some reason, inflated their kilometers. So I'm not sure. I'm not totally convinced that she should be liable in a personal capacity.
My lady, the operative element would be the question of the presence or otherwise of fraud. And we submit that we have not conducted an investigation into prior dealings of the first respondent to see as to whether when it has always been involved in fraudulent activities or not. But what we submit is in the case currently before the tribunal, there has been elements of fraud perpetuated by the first and second respondent, with the second respondent being the actual driver for and on behalf of the first applicant, the first respondent.
And then the other aspect I have is in your particulars of claim, where you say I relied on the driver. I'm not sure if I'm talking about the right one, because both this and the other matter are so identical. But we have no evidence on who the driver is, what route he followed. There's just a dearth of information. And then you have your expert who's relying on what was put to him as the alleged route when he works out the difference. But there's no confirmatory affidavits. There's no names of those drivers that are allegedly you drove. How do I know? You can say anything in an affidavit, and am I then to accept it?
As the clerk, please, my lady, perhaps I will indicate that, if I may ask for your ladyship's indulgence for just 1 moment.
Sure.
My lady, at paragraph, at page 17 of the founding affidavit, paragraph 17.
Sorry. Oh, so this is not the one. Then I think this is the one that applies to the other. The other one says I spoke to drivers and there's no names of the drivers.
I'm indebted to a ladyship, manager.
So is Moketsi here? Does he put up a confirmatory affidavit?
He does not, but Miss Mokokwe had. There is no confirmatory affidavit by the driver, but there is a statement, a sworn statement by the investigator who had spoken to the driver, and that should meet the requirement of the tribunal, my lady.
Yeah, but Moketsi, isn't she the one of the, what is she? Let me just see.
Moketsi is the driver, my lady.
Yes, and who made the how can somebody else make a confirmatory affidavit about him?
No, I'm saying he did not make a confirmatory affidavit, my lady.
So where does that leave you? How do I know what the route was? It's just hearsay, isn't it?
The route, my lady, had been defined in the contract between the parties, and that same route had also been, is the same route that the investigator had taken and had confirmed himself that this is the actual kilometerage. And after having satisfied himself of the kilometerage, he had then gone on to speak to the principal, Mrs. Mokoke, and had also spoken to the driver himself, Mr. KP Moeketsi. And of course, he had also spoken to the second respondent as well, who did not, my lady, I must say, who did not dispute this, but had merely indicated that she was using a different route. But that would have been on the basis of the contract that they had with the second applicant, my lady.
So she never disputed the route?
As the court, please, my lady.
In the opposing, yeah. Okay. All right. I'm just need a little bit of information on this piercing the corporate veil. I think I need, before I grant you a judgment, I don't think I'm going to have time now, but I'm going to just check up. I'm working from home, so I don't have access to research, unfortunately. So I just want to have a look a little bit more into that, and then I will grant the judgment once I've been able to get my researchers to find me the information, because they're clearly not here, and that's it.
As the court, please, my lady, perhaps also I could assist if her ladyship so wishes. I could also file further notes or heads just to clarify that issue alone. Perhaps her ladyship might find that useful as well.
Yes, and then prepare the draft order with the amended amount.
I will do so, my lady. By when should I file this supplementary note?
As soon as you can.
As soon as I can. I should be able to do so within 48 hours, my lady, or less.
That's perfect. Okay.
Please, my lady.
And in that case, I will then grant the order. Yeah.
That's the part, please, my lady.
Right.
That being the case, will I be excused from the hearing, my lady?
Yes, you are. Thank you, Mr.
I'm indebted to your ladyship.
Mr. Maratiwe, where are we with you? Can you hear me, Mr. Maratiwe?
My lady, I see that Mr. Mahlangu has not yet joined in. When I spoke to him, he requested for about 20 minutes, and that was at about 20 to 11 when I spoke to him. I see he has not yet logged in.
So let's give him another 10 minutes.
My lady, as I'm speaking to you, I see a call from him. Might I take it too?
Yes, of course.
To check what his whereabouts.
Yes.
The court pleases. My lady?
Yes.
I just got off the call with Mr. Mahlangu. He says he's now at a place where there is electricity, and but he has not got the email yet. He's about to call Ms. Mashitiso to send a link to an alternative email.
All right. We'll give him 5 minutes.
Okay, my lady.
Okay. Okay. Thank you, Mr. Moratiwe. Mr. Matlango, I see you've now joined the party.
Good day, Judge. And may I, before we even go anywhere, just my apologies, Judge. We're sitting with a unique situation in Mafikeng, where my offices are located. We've been without electricity for the past 2 weeks. So the towers are a bit
You mean
troublesome.
constantly?
I beg your pardon?
Constantly without electricity?
Yes, the power station, whatever they call it, was I think it exploded some 2 weeks back. So they've been trying to repair. They promised that it was going to be restored yesterday evening, but up to now they have not done so. So what we normally do, we then go to Mabat, which is the neighboring township where most of our courts are located. But now they are being load shed since 8 o'clock until 12 o'clock today. So it's that stage 6. For our load shedding. So that's why I've been struggling to get hold. The emails are just coming in through now because I've moved to a separate area where it's a different grid. So at least I'm successful in that regard. But the normal process that we would use is not working out for us, because even if you have a running generator, because the towers are not connected to your generator, so you just like then. So I apologize to the court and to my colleague and to the court staff as well.
I was quite annoyed. I said that to Mr. Moratiwe that you knew in advance that this matter is going to go on and you should have made the alternative arrangements. But I see you do have a huge problem, so I accept.
Yeah.
Okay.
Thank you, Judge. Thank you very much.
Let's proceed. Mr. Moratiwe, let's deal with your matter.
My lady.
Mr. Moratiwe, we're breaking up.
My lady, I had a chat with Mr. Mahlangu this morning.
Yes.
Mr. Mahlangu indicated that he is going to seek a postponement of the matter. So I think it is an appropriate time for him to move his application.
Sure. Mr. Mahlangu, you have the floor.
Thank you, Judge. Thank you, Counsel. Judge, the respondents are sitting with a unique situation. When the matter started out with the papers that were filed by the applicants, we were able to respond on those papers. But when the applicants were then afforded the opportunity for them to now supplement their papers, it brought about a new dimension for us. Now, as per the last postponement when we were before you, my lady, what we did then, in accordance with those timelines, we then attended at the department, that is now the second applicant, to go and seek the following documents. A report of the inspectors who would travel with the buses as and when they do their pickups and drop-offs at schools. So on irregular alternatives, at irregular intervals, the department would dispatch inspectors to travel with the buses, whereas they're able to record the kilometers in real time, as opposed to what would appear on the contract. So we asked for a copy of those reports because they stretch over an extended period of time. What also we asked for was communication between the department and my client to the effect that when the kilometers are adjusted, either upwardly or downwardly, there'll always be communication from the department. So when they submit their travel claims, that communication will be attached to the invoices, that which they seek to have paid. That is the second thing. The third document that we're requiring was the the contract subsequent to the contract that this court is seized with now. The contract that came after this contract that we are seized with now, my lady, then uses the kilometers that we are said to have been, we created ourselves. So what the department did with the subsequent, when this one lapsed, with the subsequent contract, they then moved in line with the new, what you term now the new kilometers, which are the kilometers that we are being sued for. So previously, for instance, if the kilometers were 60 per day and our claims were 62, when the department issued the subsequent tender to this one, they did it at 62 kilometers. So we want that schedule, because we do not have that schedule. Our client did not participate in the subsequent tender, so he is not privy to the new schedule of kilometers and so on. And the steps that we took, we first wrote to the Scholar Transport Management, the Scholar Transport Division. The person of, I think the gentleman's name, the director in that division is Mr. Patrick Mohono. We did not get a response from him, a written response or an acknowledgement of receipt. And then we wrote a reminder and another reminder. And what we did then, we just walked to the department, because it's about 5 kilometers from us. We went to the department. I met personally with the HOD, Mr. Murule, and informed him of our predicament and what we required from the department. And his undertaking was that he will dispatch, rather he'll convey the message, he'll cascade the message downwardly to the responsible officials and request them to then provide us with the information that we need. As at last week, when I sent an email to Ms. Zondi to indicate that we had sent a written demand in terms of PAIA, when now we want to force them to give us the documents through PAIA, because we made a request to say, please inform us who your deputy information officer is, so that we can request the document, we can follow the process. What is your process flow, and who is the person to write to? So we did not get a response from them on that. And the reason why we need this information, my lady, what we need to show without necessarily giving testimony, what we need to show in response to the applicant's application is that the kilometers that we claimed was as per agreement of sorts between the operators and the department. That's number one. And the only proof for us to get is the reports from these inspectors that will be dispatched by the department. Number two, the communication from the department. That includes a communication, my lady, if you permit me, communication further from the department that said that there was a shortfall in payment due to the operators. And some of the operators were actually paid this shortfall, which was occasioned by the kilometers that they had claimed from the department, but the department paid a lesser amount. So there's a shortfall on the basis that the kilometers that you actually travel are more than what is contained in your contracts. For us to be able to prove that, we'll need that information. It is pertinent that we get that information. Now, as the respondents, we are cognizant of the timelines that were set by this honorable court. So, and the reason why we were unable to then file anything was that, my lady, and I've said this in my email to the instructing attorney, to Advocate Morekwe, to say that it will be foolhardy for me to file an affidavit, refer to annexures and attachments, but fail to annex those documents, because those documents are pertinent for this honorable court to arrive at an informed decision insofar as this tender is concerned. Because my clients argue that they did not defraud the department. In essence, the department had created an environment that is not required for education, had created an environment that did not go in line with what was contained in their contract. If I be permitted to make an example, these farm schools, when the year begins, you will be told that you have learners in area A, B, C, and then your drop-off point is area F. But then when you get there, you get to the school principal tells you, no. You have to go and pick up at areas D and E. Those are new students who stay from far, who do not stay in the same farm as the areas A, B, and C. So the buses will then make a detour to areas D and E for the schools to get a complete attendance list of all the learners that are registered for that school. So there will be that adjustment in the actual. That's why the department will dispatch inspectors to do a real-time evaluation of the actual kilometers traveled. And beyond that, my lady, what you would get then is that because these are farm schools, there's a propensity that's why you'll see in the applicant's papers that there's a drop. There are months where there's a drop in the kilometers. This is occasioned by the fact that when I say a drop, I mean that it would be lower kilometers than the one the department has contracted the service providers for. So they will claim lesser. And that is occasioned by the fact that these children will go to what you call a harvest at a certain point in time, because their employers would say, you don't go to school, you go and do this harvest, and the months will be somewhere, I think, in the harvest period, so they will miss school for that. So the school principals will file a report with the department to say that I have X number of learners who are going for a harvest, so they won't be picked up, or they should not be picked up by the buses. So you have also that arrangement. We need those reports from the school principals to the Department of Transport to notify them that we have learners who have gone for a harvest, then they'll only return after the harvest is done, my lady. So we need that information. That information is pertinent to our response, my lady.
Okay, Mr. Mahlangu, I hear you. But how long have you had since this matter was right? It's right at the very, very outset, even when the notice of motion was issued, you knew exactly the case you had to meet.
I agree with your ladyship. Your ladyship,
So,
I don't know if your lady was.
This is a long time ago. This is a few years ago.
Yes, my lady. But your lady would recall that, I don't know whether your ladyship is aware that when the matter came out, when it was before your sister, Justice Mudipa, there was an issue that she raised. There were actually two issues that she raised. The first issue was whether the notice of motion was a correct process. So there's an issue of process, whether the notice of motion was a correct process. That's number one. Number two, whether the applicants ought to have brought this application considering the issues at hand, because there were many issues that she had raised with regards to the contents of the application. That's why then there was that stop to say that, look, applicants go and get your house in order and respond to these specific questions. That in itself occasioned a delay of sorts. So when the matter came back and we were dealing with this, when the court then granted the permission, or rather, yes, the permission to supplement. That's why I said when I said that with the response that we filed to the initial application, that would have been sufficient. But now with the leave to supplement the application, then it became apparent that we needed to adjust our papers accordingly. And this information, in our view, ought to have been brought by the applicant, because it's information that resides with the department and not with the service providers.
So if I'm just looking at it from this perspective, I still have to hear Mr. Moratiwa on all of this. If the court were to be inclined to grant you a postponement to obtain that evidence, there seems to be a dispute of fact regarding the routes traveled and whether there was an amendment to the contract, a tacit amendment. Is that it?
It was a tacit amendment because the actual contract was never, there was never an addendum to the actual contract. But how they would operate is that.
But does a written contract allow tacit provisions?
Well, that's another thing that we have to consider, my lady, because what they would do, you must remember, my lady, that's something that I don't see appearing in the application, is that the department will tell you that your kilometers are 55. If you bring 56, they won't pay. They will return them to you until you claim for 55. And that is occasioned by the real-time assessments that were done by these inspectors that would be dispatched by the department. So it was never an instance where the service providers make out the kilometers. So if your kilometers are not in line with what the department has in its own schedule, you will not be paid. So that's another difficulty that we had. So for us to be able to say, the reason why we're saying that there's a dispute of fact, insofar as this contract is concerned, is because, and we need these documents to show to this court, but it's not enough for us to allege it without providing the actual documentary proof that suggests that this is why we are saying there exists a dispute of fact, my lady. And these documents are pertinent to this application, to this response.
So, Mr. Mahlangu, okay. How long or when do you anticipate that those documents will be available?
My lady, I do not want to mislead this court, but what we have done is that we have started we're going to launch a PIA application in the Northwest High Court, where we are based, to compel the department and to give us these documents, because our written requests have gone unanswered, my lady. So I do not want to commit to a time frame, but I'm hoping that once they receive the court papers, they will act right and they will then give us the documents, my lady. But if they do not do that, I'm afraid, my lady, it will be the issue of us having to see through the PIA application.
Okay, thank you. Mr. Maratiwe?
As a court pleases, my lady, my instruction is that we should oppose this postponement application. The reasons for oppositions are the following, my lady. This application has been there for almost 3 years now. The issues that my learned colleague is trying to address now with this new process of PAIA, they could have done that a long time ago. They did not do that. The respondents are hiding behind the supplementary affidavit that was filed. To say it, they are hiding behind that. They want to say because of the supplementary affidavit, we need to bring this. There is a need to request this information, but I will illustrate that that is incorrect, my lady. The supplementary affidavit does not bring new evidence with regards to the routes. There is no dispute about the routes. What is in dispute? The respondents are simply saying the routes where the kilometers were verified. They are not saying this route starts from this point to that point. They do not say that in their papers. They simply say they were verified by departmental officials. The supplementary affidavit only seeks to quantify the inflated kilometers, my lady, nothing more. It is just a quantification exercise. Now, my lady, this matter was case managed by President Modiba. And in the case management, my lady, actually it was case managed, and then the matter was set down for hearing in October last year. And in October last year, the applicant had filed a supplementary affidavit in August. And in October, the court made an order that the respondents who were represented, my lady, it made an order, and the order is also part of the supplement of on the case lines, my lady. The orders read as follows: that the matter is postponed to the 4th of March. The respondents shall file an answer to the applicant's supplementary affidavit on or before 21 October 2022. I must emphasize this date, my lady, because these dates were agreed. We were in court. My learned friend never said, my lady, it is impossible to, the date that you are putting there, it is impossible. The dates were almost by agreement, my lady. That is why that order was made. Now, the difficulty that my learned friend has is a court order stands up until it has been set aside. He has failed to comply with the respondents, rather, my lady. They have failed to comply with a court order. They are coming to court with dirty hands, so to speak. And the tribunal cannot come to the assistance of a person who comes to court with dirty hands. It is not only that order that has not been complied with, my lady. On the 4th of March, before your ladyship, this issue was again raised. The respondent saying, we need to file supplementary affidavit. And at the time, they said they were not aware of that order. The order has been provided to them, and the order that your ladyship granted was that the issues relating to the supplementary affidavit, they should have been finalized when we come here on the 8th. That they have not complied with the second court order. Now, here we are, my lady. There is an application for postponement from the bar. There is no evidence placed before you as to why should this matter be postponed. There is no formal application being placed before your ladyship. The application is moved purely from the bar. My lady, we submit that this is an abuse. And this application has to be refused, my lady. This matter, you cannot come to the assistance of a party who comes to court with dirty hands. They have had an opportunity, my lady, from October. The request that for PAIA, access to information, my lady, it was only made last week. If I understand my learned friend correctly, it was only made last week when we were in court in October or in March already. Why did it not make that application immediately when the matter was postponed in March? This is just a delaying tactic, my lady, that we are strongly opposed to. This matter must finally be heard on its merits, my lady.
Thank you. Mr. Mahlangu, any response? He's quite right. I do not have a formal application for an adjournment.
Thank you, my lady. And we take the point from Advocate Moretti with regards to a formal application for a postponement. However, it does not prevent this court from considering an application from the bar. There's a plethora of case law to support that. My lady, the reason we're bringing this application now and from the bar is because whatever attempts the respondents have undertaken have hit a roadblock. Now, this roadblock is on the basis of the second applicant. I understand the SIU and its role in this whole thing, but what I do not understand, because the second applicant is party to these proceedings, they ought in the minimum to have been, how do I put this, to have been considerate to our request over a period of time. And the reason why I make this point is simply because despite the fact that we are unaware of we've never seen a copy of the report which brings us before you, my lady. We have never made bones with regards to that, and we thought we'll respond to what we see before us. We'll make bones of what we see before us, and we'll take it from there. But when the respondent speaks about in its amended papers, the applicant speaks about inflation of kilometers. It takes us now to the very issue that I want to address with this honorable court, with the very issue that occasions us that causes the need for these documents. That is the issue that says, if your contract says point A, B, and C, but in the long run, the department includes D and E as a pickup and a drop-off point, and they do not adjust or amend the contract accordingly, and that information is not brought to this honorable court to say that actually these service providers, these operators do not do 3 pickups, they do 5 pickups, but their contracts say 3 pickups. And when you look at the invoice would appear as if it's an inflation of the kilometers, actually the kilometers traveled, but it's actually a true reflection of the kilometers actually traveled. And something that I need to draw this honorable court, I think, is that when these operators submit
Stop. You are telling me the same thing over and over again, Mr. Mahlangu. You're not telling me anything new.
Okay,
you're not telling me anything new. And Mr. Moretti was right. You knew all along what your story is going to be, and you didn't bring this application to compel the information. You had from October. You already had an order by the court. You didn't comply with it. Then you had March, where I made a direction, and you've done absolutely nothing. We are now sitting in May, and you've done nothing. I think Mr. Mahlangu, and then you don't bring a formal application to this court to extend the time limits, because you know that this matter is set down for today. You knew well in advance you're having these problems. You should have then informed the court that you were not going to be able to comply with the time limits because these are the problems, and then you're going to institute your application in terms of fire. But you didn't do all that, Mr. Mahlangu, and Mr. Moretti is right. You don't come here today with clean hands.
I agree with the court, and I agree with Mr. Moretti. Maybe then to deal with the issue of the court would remember when we were before your ladyship in March of this year, I had made the issue about the issue of the previous order from your sister, Judge President Mudipa, with regards to what was supposed to have transpired with the amendment of the papers and so on. Hence, this honorable court then came with the new directives and the new timelines that they were set in March of this year. So that is in response to the issue that we had since last year, October, to deal with this issue. I'm just trying to raise that issue to say that
No, but
there was.
when unsure about what the order was, then it was the onus was upon you to clarify it with Judge Modiba. Not wait until we have another hearing in March.
I understand that, my lady.
No time periods, Mr. Mahlangu. However well-intentioned it might have been, but time periods are there. The court gives directions, and the reason for that is we need finality in this matter.
I agree, my lady. My lady, I shudder to think of a situation where this honorable court will make an order based on incomplete information, and where pertinent information then appears that may have swayed this honorable court to a different decision. That information was never placed in the hands of this honorable court, or in front of this honorable court. That's what I want to circumvent, my lady. I do not want by any stretch of the imagination to delay these proceedings. My clients have been they've been more than frustrated by these processes. And insofar as us acting out...
No, what you're saying is you've been frustrated, but you're not telling me that on the 2nd of December, I wrote a letter. On the 3rd of March, I made a telephone call. I spoke to somebody. On the 5th of February, I contacted so-and-so. I needed this information. They refused to give me. I have nothing to that effect, Mr. Mahlangu.
I did not get the last part, my lady.
Say I made all these attempts. You might have done absolutely nothing.
My lady, the last part of your lady's...
I said it's easy for you from the bar to say I made all these attempts to secure these documents. But what I'm saying is you could have absolutely done nothing until the morning of this hearing now to say to me, I did all of that. But I have nothing before me to say you did it, that you did make these attempts and that you were unsuccessful or you reached a stumbling block.
I hear, my lady, and I do not want to belabor the point of my frustrations with the department, my lady. And to try and cushion the blow to the applicants, we have offered we have tendered the wasted cost for today, my lady. I do not say that corrects the shortcomings of the respondents. I'm merely saying that to try and cushion the blow to the applicants, we've tendered costs for today's postponement. The only difficulty that we have right now is the timelines, my lady. Do we when will the department respond? And remember, this is the department's case again, my lady. And for them to keep quiet and not respond to our written request and our last request in us not threatening but indicating that we're going to move an application in terms of PAYA, and them to fold their hand and not say anything to us, it's something that, well, the respondents, there's nothing they can do except approach a court to try and compel them to provide us with that information. Because we submit with respect, my lady, that information is pertinent. It should find its way to this honorable court, my lady.
When did you inform Ms. Zondi that you're having difficulty with the second applicant?
I think I sent an email sometime, if not Thursday, it will be Wednesday last week, my lady.
Why only last week, Mr. Mahlangu?
Well, what you call the timelines for the PAYA would have expired tomorrow, on Wednesday this week. So seeing that, well,
have you issued a PAYA application?
No, I'm saying we have given them timelines to say that if you do not respond to this PAYA request, please note that by this date, so you gave them a number of days to say that they must respond within this date. If they do not, we will go to court.
So
and
when
those
did
are predetermined dates.
You send that letter to them?
The last letter, my lady, was sent on it should be the middle of April. It should be around the 14th of April, my lady, to the department.
And before
we sent a normal request for the documents. It would have been in the end of March, my lady.
And you received notice?
And then we sent a reminder, I think it was about 7 days after that. And then we phoned, and then I went to the office of the HOD before I sent the PAYA notification, the PAYA demand, my lady.
All right. Mr. Moratiwe, I think Look, I hear what you have to say about this case, about your client's attitude to this application, but I'm also concerned that the fact that they would not respond, is a great concern to me. That it necessitates a threat of a prior application and they still do not respond is a great concern to me. And look, at the end of the day, it's the interest of justice, and so I'm inclined to grant this adjournment. But
My lady,
he's tendered the cost, so there will be no prejudice as far as that is concerned to the applicant.
my lady, might I address the court on the issue of cost?
Yes.
My lady, we submitted that I still submitted a postponement should not be granted. But if the tribunal is so inclined, my lady, looking at the conduct of the respondent, it is unconscionable, my lady. It is unconscionable because there are 2 court orders that are not complied with. Not 1, 2, my lady.
Okay.
You cannot have a litigant come into court disrespecting court orders.
Okay. You ask for
that? I'm submitting, my lady, that if the court is so inclined to nonetheless grant them further indulgence, they must pay a punitive cost order on a scale of attorney and own client, my lady. This is a classical case that warrants that kind of an order.
Yeah, okay. Especially, but you see, the difficulty is if you have your client, your applicants who are refusing to furnish the information, it also makes life difficult for people. So perhaps, I do agree that some punitive costs is warranted, but I'd like to hear what Mr. Mahlangu has to say to that.
Thank you, my lady. With regards to the scale that that council suggests or is submitting on, I would submit that true, we do not come before this honorable court with clean hands, but that does not necessitate an adverse cost order insofar as the scales are concerned. Number 2, that it is not that we sat on our laurels and did not do anything. It is because the second applicant partook in our frustrations. The second applicant just elected to ignore the written request from our officers. As such, they should not be without blame. I understand the frustrations of the first applicant, but the second applicant is the client of the first applicant. So it is incumbent on the second applicant to assist the process as much as it can. So under circumstances, a punitive cost order may not be warranted, my lady. And to even suggest a attorney and own client, it's under very, very, very grave circumstances, and it cannot be submitted or by any stretch of the imagination suggested that the current set of circumstances warrant that much of a punishment to the respondents, my lady. I would submit with respect that a party and party already that in itself is punishment enough to the respondents who want to litigate fairly, who want to litigate openly, and as such, them having to pay this cost is sufficient punishment, my lady. So I would suggest and propose that and submit with respect that a party and party scale is justifiable under the circumstances, considering the role of the individual players in this matter. As the court pleases, my lady.
Thank you, Mr. Mahlangu. I just want to know now, and we need to set directions for this matter. When do you, Mr. Moratiwe, do you think your clients would be able to furnish this information, or should they persist with their prior application?
My lady, I have difficulty because we are acting on behalf of the SIU, and the SIU is acting on its own name. The department, I cannot make any commitments on behalf of the department.
Okay. So you're not acting for them?
Yes.
Okay. So they're not here, they're not represented here in these proceedings? Because you asked.
Yes, and just one point, my lady. My learned colleague can use the rules of the tribunal to get those documents.
Okay. All right. Then I think let's set a time frame, Mr. Moratiba. Can you just work that out? We adjourn these proceedings sine die or to a date.
My lady, my inclination is sine die because we don't know when those documents are going. They are beyond our control.
Okay. And I think we need to put pressure on the respondents to institute their application by in terms of hire by a certain date.
Yes, my lady, that would be in order.
So, Mr. Mhlangu,
their time would have expired by tomorrow, so any day from Wednesday we will then lodge the necessary papers. We've already drafted them. It's just for us to waiting for the timelines to lapse so that we go and launch them with the Northwest High Court and have them served on the same day, my lady. But what I will do then, I would also request the assistant of Mr. I beg your pardon, Counsel, Advocate Moreto is instructing attorneys, Ms. Zondi, because she's with the state attorney. She may be able to twist their hand, as it were, and to try and assist and expedite the process without the necessity of the PI application. But
well,
launch by Wednesday.
That can be just an informal request that you make to her. I'm not going to incorporate that as part of my order because the second applicant is not before me or is not represented here today as such. So I'm going to make this order. The matter is adjourned sine die. The respondents are directed to institute any application in terms of PIA should they not receive a response from the second applicant by the 9th. Is it tomorrow?
Tomorrow, yes.
The 9th. In that case, such application shall be instituted on the 10th of May.
That is 2020.
And in the light of the concession that you do not come with clean hands, Mr. Mhlangu, and you have delayed these proceedings unnecessarily, the court grants costs on the scale as between attorney and client in this matter.
As court pleases, my lady.
As the court pleases.
Okay, thank you. Matters. Did I say it? Yes, I did say it's adjourned sine die. Thank you.
Thank you, my lady. My lady, my
Thank you, my
apologies
lady.
again for having kept this court waiting. It's not
Fine.
our. Thank you, my lady.
Okay, thank you, gentlemen.